Good morning, Ms. Strong. Are we having trouble getting courtroom two on?
Good morning, Judge. I haven't seen them come in yet.
Okay,
So I'm not sure.
okay. Well, we'll get started as soon as one of the courtrooms come in.
Yes,
Thank
sir.
you. Good morning. Courtroom two will be ready to start as soon as you all are ready for us. Good morning, Ms. Falk.
Good morning.
Ms. Watson Cafe, are you with me?
Yes, Your Honor.
Good morning. What are we doing with your client, Mr. Allen, today?
I would like to argue for a reduction in bond, Your Honor, or we can move it back to the uh
Good morning, Judge Mo.
blank.
Yes. Good morning, Officer Milton.
Okay. If it's possible, we can do Miss Angela Morrow first as soon as Attorney White comes on.
Okay, that'll be fine.
Thank you.
And Ms. Watson Cafe, going back to your client positions 1 through 4, Joseph Allen, I believe he missed a court date, and that's my normal course of business is I return those cases to the division judge and let them have modifications of bond. Is there any reason that I should not follow my general practice?
I mean, it's just going to take longer, Your Honor. But I will. Um, I that's fine. I can just file the motion over there for it to the division judge to here. I think it's Judge Richardson, if I'm not mistaken.
Okay. Good morning, Ms. Desiana.
Good morning,
Positions
Judge.
1 through 4, those are those your cases? Is he your case?
Yes, Your Honor. I was just going to ask you do what you normally do. It's Judge Richardson's case. I'd ask for it to go back to the division judge.
Okay, so we'll return that to the division judge, Ms. Watson Cafe, and let him make the determination. Do you have any other
Okay.
cases on our calendar today?
I have Miss Sneed, Sneed.
Okay. I'll see if we can get to her as quickly as possible, okay?
Okay, I'm not sure if that's going to go back to the division judge as well, because I have a motion to withdraw on that one. I haven't had any. Well,
Is that LaShawn
Actually-
Sneed?
yes,
I have that that's reset for a social worker visit for 7:30.
okay.
She came off the case, right? Yeah. Hi, Your Honor, I'm sorry, I just.
Good morning.
We saw in the record that you came off Ms. Sneed's case, in May. Was that still the status? Something was filed. This isn't, hold on, I was working on this. I just want to make sure. Is she still your client?
I didn't see an order, so I filed the motion. I was just waiting for the order. So I didn't intend to move forward with her case. So,
Okay, so if you'll send me the order, Ms. Watson Cafe, I'll sign it this morning, and then Ms. Vigiletta, you all can move forward with representation, I take it?
Sounds good. Yes, thank you.
Okay, so
Thank
if you'll
you,
get
Honor.
that, you're welcome. You just get that to Ms. Strong and she'll get it to me.
thank you, Honor.
Okay.
May I be
Anything further?
excused?
Yes, have a
Uh,
good day. Thank you.
No,
Good
that's
to
it.
see you.
Thank you. Likewise.
Okay, Officer Milton, if you have anybody that you're ready for us with.
Okay,
I'm not,
I have over here Antoinette Harris, and she's position 24 and 25. Also, I have Angela Morrow, position 37 and 38, and Kayla Page, position 41. Okay, we can start with Antoinette Harris, please. Go ahead and get AC/DC out of the way.
okay,
Come on.
is Mr. White on the line? Oh, yeah, good morning.
Speak here, please.
Good morning, Judge Monroe.
Good morning. Hey, good to see you. Let's see, have you had an opportunity to speak with her?
Judge, I just spoke with Ms. Harris briefly. This is going to be a bond hearing.
Okay, good morning, Ms. Harris. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, good morning, Your Honor.
Thank you. Let's see, who do we have on for pretrial?
Your Honor,
Oh,
Washington.
good morning, Ms. Washington. Can you give me Ms. Harris's history, please?
Yes, Your Honor. 4 prior arrest cycles. The last arrest was April 22nd of 2024 for criminal trespass. I see no felony convictions listed on the GCIC and no misdemeanor convictions listed on the GCIC. Nothing further.
I take it she missed a court date, Ms. Desiano. Thank you.
Your Honor, yes, she missed an arraignment calendar on May 22nd of this year. Judge Morrison signed a bench warrant that has a $4,000 surety bond. The state would ask that you return this case to the division judge and let Judge Morrison hear the issue of bond.
Mr. White, when another judge is issued a bond, I normally return it to them to modify the bond. Is there any reason that I should change my policy in this case?
Well, Judge, at this point, she's been in jail 21 days on this. She never received court notice. She has no convictions. And she has 4 children ranging in ages from 11 to 17 that live with her. So we would ask that you be allowed to sign her on, she'd be allowed to sign her on bond. I don't know. Very lately, there's been a lot of issues with the mail service and service being returned or not delivered at all. We've gotten a lot of this in division. So I'm inclined to believe her. There's no mention of any missed court dates prior, even though she has a couple of arrests. So I think she's very much qualified for a signature bond at this point.
Your Honor,
Yes.
I don't believe that the defendant has custody of her children. It's my understanding that her mother has custody of her children. There are some MH issues in this case. In this case in particular, she walked outside and fired a gun toward her vehicle, which is in a road. She also said, "I'm gonna kill me a bitch today." And that's why she was arrested. I mean, she also has another open case for criminal trespass against her mother. Her mother has said she is unstable. She cannot have her children. Her children are not in any danger because she doesn't have custody of them at this point. And that's why the state was offering for a plea offer that there's an MHET requirement. So again, I would just ask that this go back to the division judge. There's no exigent circumstance here.
Given the circumstance, I'm going to follow my regular practice and return it to Judge Morrison and let her decide on a modification if she chooses to do so. Good luck to you, Ms. Harris.
Thank you, Your Honor.
So what does that mean, Your Honor?
You'll get notice of your next hearing date, Ms. Harris. They will let the division judge know that you're in custody and she will make determine whether or not there'll be a modification. So you'll get your next hearing date. Okay. Who do we have next?
Next, we have 37 and 38, Miss Angela Morrow. Come on, Miss Morrow. Miss Morrow, come on.
And what are we doing with Miss Morrow, Mr. White?
Judge, we're asking you to do a non-negotiated plea.
Okay.
If I may inquire, what portion of this is non-negotiated, given that the defendant has received credit for time served, which would
The
release?
probation.
Okay.
Yes, good morning, Ms. Morrow. I'm Judge Eric Morrow. This is the state all-purpose. Good morning, ma'am. This is the state all-purpose calendar that we're doing by video. Do you agree to have your case heard by video?
Yes, sir.
Okay, can you raise your right hand for me, please? Do you swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Nothing but the truth.
Yes, ma'am. Thank you. You can put your hand down. May I get the history, please, Ms. Washington?
Yeah, sure. There are a total of 74 arrest cycles. The last arrest was June 7th of 2024, and that was for the criminal trespass. And in terms of the felony convictions and misdemeanor convictions in the last 10 years, there was a 2010 criminal trespass out of Fulton County, another 2010 criminal trespass misdemeanor conviction, and that was for 4 counts, and also a simple battery misdemeanor conviction. Another criminal trespass in 2010, misdemeanor conviction. A 2012 misdemeanor conviction for battery. A 2012 FTA. A 2012 criminal trespass out of Fulton County misdemeanor conviction. A 2015 misdemeanor conviction out of Carroll County for terroristic threat. A 2021 misdemeanor conviction for criminal trespass out of Fulton County. A 2024 misdemeanor conviction for criminal trespass and willful obstruction out of Cobb County. And nothing further. And I do know that there were some convictions prior to the last 10 years. Nothing further.
Falk.
Yes, Your Honor. This incident, there were actually 2 cases here. The first one was a theft by shoplifting. The defendant went into the store at Joseph E. Boone Boulevard Northwest, 1167. And the cashier stated she came into the location, took 2 bags of chips, and left the location. The officer actually recognized her from the video. That is how well she's known to that area. And they observed her sitting at the bus stop, walked over to her, And a drug pipe was found in her clothing when she was arrested. She was transported to Grady. While at the hospital, she was not cooperative, continually threatened to spit in the officer's face, and had to have a spit mask placed on her so that she could be taken into custody and transported without spitting on anyone. The second case, Your Honor, is an incident that happened on July 8th, 2024 at 11:15. This was at Grady Hospital. She was discharged at 11 a.m. She kept returning to the property numerous times throughout the day, yelling, harassing the Grady Hospital staff, the employees at Starbucks, and the Grady Public Safety security officers. She had to be escorted off the property several times, and the final time they placed her under arrest. So this defendant, it definitely seems to be, has a history of BHET or BHET related offenses, or MHET related offenses. For that reason, the state is asking for 12 months served, 30 days, credit for time served, 15 days. That's going to be from July 9th, 2024 until today, balance probated, $500 fine, which is required under theft by shoplifting statute, BHET. Stay away from 1167 Joseph E. Boone Drive, which is Henry's Package Store. On the possession and use of drug-related objects, count 2, we are agreeing to time served. Position 38, the criminal trespass, is 12 months served, 30 days, credit for time served, 15 days. Again, that's going to be from July 8th, 2024. Balance suspended on that case. Stay away from Grady Hospital at 80 Jesse Hill Jr. Drive unless for medical treatment. This is a global resolution, Your Honor, and I will state with 70 plus cycles, and the fact that there is a $500 fine, even if we converted that fine to community service, which the code really doesn't stipulate for, she would still have to be on probation in order to complete it. So that is why the state made this recommendation. Number one, because of her lengthy history, including an aggravated assault that was pled down to a battery in 2021, as well as and that's in the Fulton County record, as well as a interference with government property in 2017 was a felony, and she pled no to that felony. So between her history and her most recent charges, the state's recommendation, in our estimation, is fair given those circumstances. That's all for the state.
White, requested to speak on this case. Is that something that you would like him to do before you address the court, or?
Judge, that would have to be done in a breakout room. I have a feeling there would be some HIPAA issues.
Mr. Hogan?
Yes, sir, I'm present and listening.
Yes, so is this going to require a breakout room as to what you plan on informing the court of?
Were I to address the history that the counsel, let me just say this: you have very capable lawyers on both sides here. The legal issues before you today are things I cannot speak to, but as the defender suggested, and I think the prosecutor understands clearly as well, there are HIPAA issues that are behind all of this stuff. I don't know if it is the court's inclination to hear all those things, because I don't know exactly what the pending plea is and what your decision is today. However, to fully understand what led Ms. Morrow to these charges, yes, counselor is right. There would need to be some privacy involved in my communications.
Okay, thank you, Mr. Hogan.
So,
with that said, Mr. White, do you want me to hear that, or would you just like to make your presentation? I'll just have to say, I'm noticing that Ms. Morrow appears to be very agitated this morning, and that concerns the court.
Judge, the issues that Mr. Gar would speak to are exactly the reason that she's not a candidate for probation. That's the whole argument for non-negotiated plea. We're not asking any of these cases to be dismissed. The state was going to release her today anyway. She, $500 fine is impossible. Community service is going to be impossible for her, which is in your discretion, by the way, to offer. But that's crux of our argument is that she just cannot comply. We're setting her up for failure, and she's just gonna get rearrested on a probation issue because she's not compliant.
With the court's permission, I strongly agree with what Counselor has said. I understand the roles of each lawyers here. I'm not trying to get involved in any legal advocacy, but I believe any sentence today that you might accept that would involve some ongoing responsibilities with probation or community service, as the state's attorney has mentioned, that's just an invitation for you to meet Ms. Morrow again.
So can I get some clarification, Your Honor? Is PAD saying that they are going to take her into their program upon her release?
Shall I respond to?
Yes.
Ms. Morrow has been a PAD participant for at least a year, during which most of that time I've worked with her case directly. Given the background of HIPAA-informed issues, let me just say that were you to release her today or on any given day, she is unlikely to call us and accept services from us. However, this community has other mental health resources, and we have been for the last 2 weeks since this arrest, we've been engaged in discussions with several of the public defenders, including Mr. White, as well as the social workers in their department. And our fervent hope is that there be some kind of evaluation or treatment with the courts, or rather the jail's mental health services. Yes, Counselor, she is in fact a PAD participant, has been a long time, but it has been some time since she has been able to cooperate with us and to receive service.
So, sorry, Your Honor. No, I think you've got it. So please take it away.
No, I'm just saying, how do we help her the best? You know, I don't want to put her back on the street without any kind of plan put in place that she is, you know, possibly be a recidivist and be right back before us.
Let me tell you, many of us share exactly the question you raise. I had a long conversation with Paul Barnes. He's a public defender in Mr. White's office with a mental health background. And we believe that this circumstance is one that the law really isn't able to handle. She falls in a very difficult situation that our society has not provided for. I know you don't want to discuss philosophy because you have a busy morning, but let me say that at a minimum, we believe it's really important that the mental health services in the jail meet with her before her release. I also do need to go on record as saying that our organization is fervently consent-based. So if Ms. Morrow were to say to you today in a way that you believed she understood, I want to go out today and I want to accept this plea, we will not go on record as opposing that. However, I think, Your Honor, in noticing her behavior, there may be some questions as to capacity to enter that book. I know I'm being very obtuse, and Mr. White had suggested, but I know the court's got a busy calendar. I know.
No, I mean, our calendar can be as busy as possible. I'm going to give the time necessary for everybody that comes before me. I want to make sure that we do the right thing, not only by the community, but the right thing by Ms. Morrow. And I know that, you know, just her appearance today, Mr. White, she's very agitated, it appears. That concerned me that she would be agreeable or even capable of taking a plea to these. I would like to get some kind of plan set up for her. And I don't know, to be honest with Mr. Hogan, and I don't know what that would be, but I don't think it's in her best interest just to, without any supervision, to just put her back on her own.
And Judge, I understand that on some level, but on another level, the jail system is not the place for her to get mental health issues, mental health care for them. It's, you know, and it's completely, as Mr. Hogan stated, you can't, it's not required, the PAD program, it's voluntary. There just isn't a place for her. The jail is not the place for her. But I mean, given it being released might not be exactly the place for her. It is more likely be the place for her to. I'm not doing a great job explaining my thoughts here, but I didn't really expect this.
No, I understand. Has she had a social worker visit to at least give the court some inclination of competency?
My understanding is there has been a social work visit. The other option would be a competency calendar, but again, I'm pretty sure where we're gonna come down on that, and it's just going to keep her incarcerated for that much longer. These are misdemeanor offenses. The bulk of her history is just misdemeanor nuisance offenses. I'm not saying there aren't a couple of others, but that's the bulk of her history. It just seems unfair to keep somebody in jail because they have these issues.
Well, I'm not suggesting that. What I'm suggesting, Mr. White, is that if I have a concern about her competency this morning. If you had somebody come before me and say, we've talked with her, we believe that she's competent, if she wants to take the plea, then that would make the court feel a bit more comfortable. I'm back on this SAP calendar on Thursday. I am happy to reset it till Thursday so that you can have someone speak to her so that I can get an idea of her competency. And maybe in those 2 days, if you all can put your heads together and think of how best to help Ms. Morrow, that would be what I think I'd feel most comfortable with. Okay.
Right. And Your Honor, if I just may say, I just want to let PAD and the PD's office know that I do understand and empathize with what is happening. But at the same time, if we release her with zero resources, she will come back to the jail. She absolutely will. That is the history that we are looking at. She will be right back here and we will be having this conversation again.
Either way.
So I am more than happy to try to assist. I will reach out to my victim advocates to see if there are any resources that they can assist with. But just releasing her with nothing else is not a solution.
One last thing from PAD. I appreciate that, Counselor. And in a former life, I've been both a prosecutor and a public defender. I just want to say that let's give her all we can. I would be in favor of the court's recommendation. In that period of time, I will continue discussions with the public defender's office. I cannot oppose what the prosecutor has just told you. That any kind of supervision probation, but I suppose that would be something we would address again Thursday. And I wonder if the court at that time might set aside some time that we could go to the breakout room and approach the bench, not publicly.
And that's fine as long as it's fine with Mr. White, who is her attorney, and we have a competency calendar on Thursday anyway, so we'll be in a private breakout room. Okay, so let's do that, if you all don't mind. So, Ms. Morrow, I'm going to see you back on Thursday, and I'll address you at that time, ma'am.
Your Honor, can we do position 41, Kayla Page?
Yes. Francois, are you there with me?
Yes, I'm here, Judge.
Okay.
And
Okay, you have a right to remain silent, Ms. Morrow. I'll be back with you. You'll see me again next week, ma'am. Okay? Thank you.
I think I'm free today. Please.
We'll talk on Thursday. Okay, you'll see me again, you'll see me again on Thursday.
Don't shut the phone.
Okay, thank you. Who do we have next? I'm sorry.
Position 41, Kayla Page.
Okay. This is also going to be a non-negotiated plea.
Well, Your Honor, I mean, non-negotiated, just, of course, it's a time served sentence, but just non-negotiated as to the terms of probation and this, anti-theft course and the fine.
13 people, 13.
Okay. Good morning, Ms. Page. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video? You're on mute there, ACDC. Yes, ma'am.
Yes, I do.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Thank you. You can place your hand down. Ms. Falk?
Yes, Your Honor. This incident happened back in 2017. On that date, the defendant entered the Walmart at 5200 Windward Parkway and took a backpack and a phone worth $219.96 with the intention of depriving Walmart. And my apologies, this happened June 9th of 2016. The defendant's history, she has 12 cycles at this time, Your Honor. She has a theft by shoplifting arrest in 2006 that doesn't have a disposition, a theft by taking arrest in 2016 out of Gilmer County with no disposition. She has a theft by shoplifting case from 2016, which I believe is this case, which came to us. A simple battery, family violence, that case looks like it was null prost in 2024. A 2019 911 calls, unlawful conduct during 911 calls, which also has no disposition. A possession of methamphetamine from August 20th, 2019, which was forwarded for prosecution, has no disposition. A driving under the influence in 2019, which has no disposition. Possession of methamphetamine arrest in 2021 with possession of drug-related objects that has no disposition. And then this case, which was our FTA, which she was arrested on July 8th of 2024. Based on the history of theft by taking and theft by shoplifting arrests, the state's recommendation was 12 months served 38 days, credit for time served 19 days, from November 13th to November 15th, 2016, and then from July 8th, 2024 until today. Balance probated, anti-theft course, stay away from Walmart at 5200 Windward Parkway in Alpharetta, and a $500 fine. The state actually agreed as part of this plea to terminate upon completion of conditions. So that is about as much as we can offer given the circumstances. That's all for the state.
Ms. Washington?
Your Honor, I also wanted to add in addition that there are 4 arrest cycles out of Florida as well. In Florida, there is a misdemeanor conviction from 2023 for drug equipment and also a felony conviction for fleeing, and that was in 2023. There's also a 2023 battery misdemeanor conviction out of Florida, as well as a burglary felony conviction out of Florida, as well as criminal mischief and petty theft. And it does appear that the defendant has 2 holds that were listed on the GCIC that was just ran. One being out of Chatsworth, Georgia. The warrant date is January 4th of 2023, and it doesn't specify what it's for. And also one out of LJ, Georgia, for a failure to appear, and that warrant date is August 28th of 2023. Nothing further.
And Your Honor, given the additional circumstances that pretrial just laid out, the state would ask, since this is a non-negotiated plea, we would not agree to termination upon completion of conditions.
Mr. Ty?
And Your Honor, I would like to ask Ms. Washington, from what I saw, she also has a hold in Florida.
No, ma'am, I'm not seeing that on this GCIC. The GCIC was just ran, and I don't see that on here at this time. So I'm
So
not sure if it's clear.
Yeah, I saw on the jailing screen that she has a hold in Leon, which is in Florida. And that was part of the reason why I thought it would be several months before she could complete any of these terms of probation. So, I mean, I just want to, the last I checked on the jailing screen, she does have that in Florida. And that's part of the reason, you know.
Well,
The incident date, oh, sorry, Ms. Washington.
I was just saying this was just ran on Friday, so if it happened between Friday and today, then that's possible, but it was just ran on Friday, so I don't know if they added something.
Well, I don't have my laptop here to check right now, but I mean, I can check in a minute. But this happened 8 years ago, Your Honor, in 2016. She's 35 years old. She has 2 minor children, 13 and 16 years old. She's lived in Georgia all her life. She has struggled with substance abuse and is in recovery. She's filed for disability benefits since then and has been indigent for her entire adult life, Your Honor. She lives with her mother and her children in LJ. She has been in custody for 16 days. This is a theft by shoplifting from 2016. And as far as I saw, she has a hold in Florida. She has 2 holds in Georgia, in Gilmer and Murray. And she has a long road ahead of her with that. And she's not in a position to report to probation or to pay a $500 fine. Or do the anti-theft course. Of course, she can stay away from that location. This happened 8 years ago. And so I'm just asking for a balance suspended. Since the underlying charges are 8 years old and she is indigent and has been for her entire life, basically, Your Honor.
I'd be willing to convert the 50 hours of $500 fine to 50 hours of community service. The anti-theft class, you can get that done very, very quickly. I'm also willing to have the probation terminate, given the age of the case, once she completes if she wants to do community service. Once she completes the 50 hours of community service and takes the anti-theft class, then she'll be done. I don't think it's fair to everybody else that's charged with this type of charge, regardless of when it was, not to have the same type of sentence. So if that's what she wants to do, I'm happy to go ahead and take the plea today.
She would be fine with that, Your Honor.
Okay. Ms. Page, it's my understanding that in case 17 CR 019383A, you wish to plead guilty to theft by shoplifting. Is that correct? Say it again for me.
I'm sorry. Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No,
You've been represented by counsel. Are you satisfied with her representation?
very much so.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
Okay, I'll accept the plea, Ms. Page. The court sentence will be 12 months to serve 38 days, credit for time served 19 days, balance probated, an anti-theft class, stay away from the Walmart on Wynwood Parkway, 50 hours of community service. The probation will terminate once you do the community service and the theft course, okay?
Okay, I have one question. Can I ask?
Mr. Ty,
Okay,
What is the question about?
the question was just about, am I gonna have to serve out the 30, how many days?
oh, it's a time served plea, Ms. Page, so.
Okay. My lawyer,
Yeah.
so I'm asking you how long they have to come get me so I can get this moved. I'm just trying to get it all moving.
I'll call you. You can call.
Okay, I'm sorry.
Unfortunately, they have a long time to come get you.
All right, good luck to you, Ms. Page.
Thank you, Your
Your Honor,
Honor.
and before I forget, did we stipulate to venue, factual basis, and identification?
Yes, we stipulate.
Okay, thank you.
Okay, who do we have next?
Next, we go to position number 21, Mr. Antoine Fowler.
I'm sorry, excuse me, I don't mean to interrupt. Judge Morrow,
No.
I do have a quick question. Going back to
Okay.
position 37 and 38 for Miss Angela Morrow, is it possible that we can do her today so she does not have to come back again on Thursday?
Well, the reason that she's coming back on Thursday is the court needs some additional information regarding her case before I can make a determination as to whether or not I think that she's competent to take a plea. So unfortunately, they're not going to be able to do that today. So we'd have to see her back on Thursday.
Okay, thank you.
Okay. All right. Tell me again where we are. I'm sorry.
Position 21,
21.
Fowler.
It's going to be a not guilty and a request for bond modification. Are you going to file a waiver, Mr. White, or should I arraign him this morning?
We'll waive reading. Arraign him here and waive reading, I guess.
Okay, so you want me to arraign him and
Yeah.
you, okay, all right. Good morning, Mr. Fowler. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, you can place your hand down, Mr. Fowler. You've been charged in case 19 CR 003075Y with simple battery family violence and battery family violence. Each of these charges carries with it a maximum penalty of 12 months in jail and or $1,000 fine. It's my understanding that you're waiving reading of the accusation. Mr. White,
Yes, that's correct, Judge.
how do you plead, Mr. Fowler? Guilty or not guilty?
No, yes.
We'll record your not guilty plea. Your case will be returned to the division judge and you'll get notification of your next hearing date, sir. What is the current bond?
So I believe it's a $4,000 cash bond. $7,000 cash bond.
May I have the history, please?
Yes, Your Honor. 12 arrest cycles. The last arrest was in 2020 for an FTA. In 2012, there was a misdemeanor conviction. I'm sorry, the defendant pled NOLO to battery out of DeKalb County. The defendant was also arrested in that incident for 4 other counts of battery, but they were no priced. In 2011, the defendant pled NOLO to criminal trespass in DeKalb County. There was an FTA in 2012. In 2016, there was an arrest for battery family violence. It appears that that case was dismissed out of Clayton County. In 2016, the defendant pled NOLO for battery family violence and disorderly conduct out of DeKalb County and served 24 months on probation for that. In 2019, the defendant was arrested for 3 counts of simple battery, cruelty, 3 counts of cruelty, but that appeared to be no priced out of Clayton County. There was an arrest in 2019 with the Atlanta Police Department for simple battery. No disposition is listed. A 2019 arrest for abandonment, and that appeared to be no priced out of Clayton County. And as mentioned, the last arrest was in 2020 for an FTA regarding one of the battery cases out of Fulton County. Nothing further.
Thank you. Are you with me, Ms. Desiano?
Your Honor, can you hear me?
I can hear you.
Okay, I'm having an issue with my video, but I will say, as far as the bond's concerned in this case, Judge, it looks like he had a $7,000 cash bond from a failure to appear in 2022. It's my understanding that there was a consent order that was entered on July 11th of this year, where the state agreed to reinstate the original bond. That was, of course, that would have happened a little over a week ago. And I believe the original bond was a $3,000 good bond. So for purposes of bond, I would just ask that the court honor the previous consent order that was just entered on July 11th. But I did not see yesterday that the jailing screen had been updated to reflect that the bond had been reduced to the $3,000 good bond.
Is that $1,500 per charge?
Yes.
Okay. Did you know that, Mr. White?
I did, Judge, and that's what he explained to me as well. We couldn't find it in the system, so we're asking that he's been held here basically an additional 12, 13 days because the order wasn't on the computer. We're asking that he be allowed to sign his own bond at this point based on that. As well as we have an affidavit from the alleged victim saying that she does not wish to prosecute the case. Obviously, I understand that it's not entirely up to her, but it is for conviction purposes. So based on those facts, the fact that he's a CDL driver, he's got a job waiting for him when he gets out, family in the area, the 2020 FTA was during COVID, which he appeared in court and there was no one there. And then for some reason, there was an FTA warrant that went out and he ended up getting rearrested, posting a bond, and he didn't receive notice for this last court date. I do believe that has something to do with the fact that there was an agreement in place to reinstate bonds. So we're asking, especially considering that he's been here another 12 or 13 days, because he was supposedly had to make a cash bond, that he'd be allowed to sign his own bond.
Your Honor, he was just in front of the division judge, over a week ago, and Judge Edie agreed to reduce the bond to the good bond. So I'm not understanding the argument of why he's now entitled to a signature bond. Of course, Your Honor typically just sends it back to the division judge. The division judge has already heard this issue on the 11th and agreed to reduce it, so.
And the fact that that judge did agree and it was not reflected, allowing him to be able to get out.
And now we can make the jail aware so that it can be updated so that he can post bond today.
And the fact that he's been in here 12 extra days because of this is the reason we're asking for a signature.
And Your Honor, he'll get credit for that time if and when he decides to take a plea or case to trial.
He's saying he's not guilty, so we're not asking for any credit for the time. He's being held here.
Your Honor, I'm not sure why the PD's office didn't just send the bond order to the jail. I've just done that. So it took me about a minute. So I have already sent it to the jail. I've also CC'd Michael Jordan with the clerk's office to make sure everybody's on the same page. Normally, they're able to let him out the same day once I send it over to the jail. I've done this before. I'm not sure why it wasn't done in this situation.
Okay, well, apparently it fell through the cracks for whatever reason, and the young man has been in custody. The recommendation is a time served plea. Given also the age of the case, I'm going to take this down, Mr. White, reduce it to $5,000 signature bond on each count, makes for a total of a $10,000 signature bond through pretrial level 1. With whatever conditions were on the previous consent bond. Okay?
Thank you, Judge.
All right. Good luck to you, Mr. Fowler.
Thank you.
Next, we can go to position number 26, Mr. Henderson. Yes, this is all you, Mr. Mike.
Okay, also not guilty with a bond modification request. Would you like me to arraign him, Mr. White?
The judge, same else. We'll waive reading and just brief.
Okay. And I only asked you, Mr. White, because prior to today, the PD's office has been filing waivers of the arraignment. If that's changing, that's fine with me, but I just have to know one way or another. So that's why I've been asking you. So with your cases, I will assume that you want me to arraign them as opposed to filing a waiver.
Judge, I'm kind of just feeling my way back into
Okay.
this, so we'll figure. As we go,
Okay.
it'll be smoother.
All right, so just whatever you want me to do, I'm happy to do it. Good morning, Mr. Henderson. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can place your hand down, Mr. Henderson. You've been charged in case 24 CR 004474Y with simple battery. This charge carries with it a maximum penalty of 12 months in jail and or $1,000 fine. It's my understanding that you waive reading of the accusation, Mr. White.
Correct.
How do you plead, Mr. Henderson? Guilty or not guilty?
Not guilty.
I'll record your not guilty plea. Your case will be returned to the division judge and you'll get notification of your next hearing date, sir. What is the current bond?
Your Honor, this is a $1,000 good bond ordered by Your Honor on July 9th. And no further contact with the victim and a stay away from the incident location. Judge, this incident happened on July 8th. Officers responded to 210 Auburn Avenue Northeast in Atlanta regarding a battery. The victim in this case, Nakobe Merriweather, advised the defendant slapped her in the face. This defendant has 23 arrest cycles, a prior battery, a prior simple battery, family violence, a prior violating family violence order from 2018. And of course, you heard this case on SEA and ordered a $1,000 good bond. The state would request that you keep the same bond that you previously ordered. Thank you.
Mr. White?
Judge, Mr. Henderson actually has a job at the Marriott Hotel Marquis. It's been there 3 years. They're actually holding his job for him for a little while longer if he can get this resolved. He has been in jail now since the 9th. He vehemently denies the charges. We're asking that he be allowed to sign his own bond.
I don't see that any circumstances have changed since, especially since I'm the one who gave him the bond. I don't see that I'm willing to modify it at the present time. Good luck to you, Mr. Henderson.
Judge, can we reset him to next Tuesday then?
Yes,
Or
on the SAP calendar.
actually, give me a minute. We'll get back to you on that.
Okay.
All right.
And I am on that calendar, so I would be the one to see him.
Okay, thank you.
All right, let's see.
Actually, Judge, the state's willing to hold it. We bring him back, yeah, we'll bring him back next Tuesday to SAP.
Okay,
Thank you, Judge.
you're welcome. We'll see you next week, so.
Next, we go to position number 29 through 32, Mr. Sidney Johnson. Sidney Johnson.
Good.
And let's see. Mr. Johnson's cases are going to be negotiated pleas and no pros. Is that right?
That's correct, Judge.
Okay, good morning, Mr. Johnson. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video. Do you agree to have your case heard by video?
Yes, I do.
That wasn't a yes, Judge. You didn't catch it.
Okay, thank you. I'm sorry, I thought he was already seated. I apologize, Mr. Johnson.
That's all right.
Can you raise your right hand for me, sir?
Right hand. Raise your right hand.
Okay, do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, Mr. Johnson, you can put your hand down. Thank you, sir. Yes, Ms. Falk.
Yes, Your Honor. On Kate, position number 29. The state's recommendation is 12 months served, 72 days. 18th July 5th, 2024 until today. Balance suspended, stay away from Walgreens at 25 Peachtree. On positions 30, 31, and 32, the state is entering a null pros. We would ask the defense to stipulate to venue factual identification for the purposes of this plea.
Standing. We have a standing stipulation.
Okay. Mr. Johnson, it's my understanding that in case 23 CR 004090E, you wish to plead guilty to criminal trespass. Is that right? Are you under the influence of any drugs or alcohol this morning?
So you just gotta say it out loud.
Okay, so that's a no, right?
You said no, sir. Yeah.
Okay. Thank you. You've been represented by Mr. White there. You happy with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up that right?
Yes, sir.
Has anybody forced you or coerced you to plead guilty?
No, sir.
Okay, I will accept the plea as negotiated, Mr. Johnson. Good luck to you, sir.
Yes, sir.
Thank you, Your Honor.
Yes, sir.
I'm gonna be released. Good luck.
We can go to, we can
Do
go
we
to
have-
position number 20, Johnny Felton.
So the judge is up here in the corner.
Yeah.
Good morning, Mr. Felton.
Good morning.
Good morning, sir. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Is that okay with you? That we do this by video?
Mr. Felton?
Oh, yeah.
Okay, thank you, sir.
Mr. Felton is a little hard of hearing. I might repeat some of your questions.
Okay, thank you, Ms. Vigiletti. Can you raise your right hand for me, Mr. Felton? Can you raise your right hand?
Mm-hmm.
Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yeah.
Okay, you can put your hand down. Thank you. Ms. Desiano?
Your Honor, the state's recommending 12 months probation, serve 42 days, credit for time served 21 days. That would be from July 3rd, 2024 to today. Balance suspended, a stay away from the Texaco at 117 Lee Street. And at this time, it asks the defense to stipulate to venue, factual basis, and ID for purposes of the plea.
We do stipulate, Your Honor. I've spoken with Mr. Felton a few times. He knows he's got to stay away from that Texaco, so I don't think we'll have any further incident.
Okay. Mr. Felton, it's my understanding that in case 24 CR 004398C, you wish to plead guilty to criminal trespass. Is that right?
Yes.
Are you under the influence of any drugs or alcohol this morning?
No, but no.
Okay, you've been represented by Ms. Vigiletti there. Are you happy with what she's done for you?
Yes.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up that right?
Yes. Uh-huh.
Has anyone forced you or coerced you to plead guilty?
No one just lady said I have to plead guilty and get out today.
Okay, I'll accept your plea. Now, you know you can't go back to that Texaco, right?
Right.
All right, so
I
don't go
just
back
want to
there.
know, I have another facility. I just go around cleaning up.
He tells me he lives in the area, Your Honor, but we have talked about it many times. He cannot go back to that Texaco.
There's several around there.
All right, good luck to you, Mr. Felton.
All right.
Thank you, Judge.
What time I'll be leaving?
I'll talk to you over here, okay, Mr.
Can I have one of the picture ID?
Sure, come on. Thank you, Judge.
You're welcome.
Next, we can go to 33 and 34, Mr. Chad Jones.
Negotiated plea and a null pros.
That's correct. Thank you, Howard. That's correct, Judge.
Good morning, Mr. Jones. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
No problem. No problem, Mr. Eric.
Okay. Can you raise your right hand for me, please? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down. Thank you, sir. Ms. Falk?
Yes, Your Honor. State's recommendation is 12 months served, 46 days credit for time served, 23 days. That's going to be from April 18th to April 19th of 2024 and July 3rd to July 3rd to today. Balance suspended, stay away from the sit-go located at 2320 Cheshire Bridge Road, Northeast in Atlanta. We do ask the defense stipulate the venue, factual basis, and identification for the purposes of this plea. We will be entering a null cross on position 30 for the FTA.
Okay, Mr. White?
Judge, obviously, we'll be stipulating, unless otherwise notified. And we just have to please negotiate.
Mr. Jones, it's my understanding that in case 24 CR 002034Y, you wish to plead guilty to criminal trespass. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir, Your Honor.
You've been represented by counsel. Are you satisfied with his representation?
He's well.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, Judge.
Has anybody forced you or coerced you to plead guilty?
No.
Okay, I'll accept the plea as negotiated, Mr. Jones. Good luck to you, sir.
Thank you, Your Honor.
Thank you, man. What's your name?
Tom White.
So that's good.
Yeah.
Thank you, Eric. Thank you, Eric and Joe. Go.
You're good.
You're welcome, sir. Good luck to you.
All right.
Your Honor, I'm gonna go ahead and pull out the next group. In the meantime, we can go to position number 49 through 50. Mr. Nicholas Taylor.
And these are negotiated pleas, Mr. Ty?
Your Honor, the only thing not negotiated about it is that I'm just asking that the only condition is a payment of stay away, of course, but the payment of a $300 fine, and I'm just asking that the probation terminates upon payment of that fine. He does want to move out of the state. And it's difficult to transfer.
Any objection to that, Ms. Falk?
On Ulysses Seabrooks, Your Honor?
No, I think this is Taylor, position 49.
Okay.
Tyler? Oh, sorry, Taylor.
Just wanted to make sure I was on the right case. Position 29. All right.
And did you
I
hear the
just needed
request?
to,
Okay,
yeah, I did hear the request. Okay. I'm sorry. I heard position 29. I'm assuming you said maybe
49.
49. Okay. Sorry, my internet is acting up, so I'm kind of getting every other word. All right. The state doesn't have an objection to termination after the
Okay.
payment of the fine.
Thank you. Good morning, Mr. Taylor. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. Can you raise your right hand for me, please? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay. Yes, Ms. Falk.
Yes, Your Honor. The state's recommendation on this case is on the criminal trespass. Count 1, 12 months served, 32 days, credit for time served, 16 days. That's going to be from February 13th to February 15th of 2022 and July 11th of 2024 until today. Balance probated, stay away from the Marriott Marquis at 265 Peachtree Center Avenue, Southeast in Atlanta. Count 2, 12 months concurrent with count 1 with a $300 fine. And as we agreed, this will terminate upon payment of the fine. The position 50, which is the FTA, the state will enter a null pros. We do ask the defense to stipulate to venue, factual basis, and identification for the purposes of this plea. That's all for the state.
We stipulate.
Mr. Todd?
Yes, we stipulate.
No, it's anything else?
Oh, no, Your Honor, that's all.
Okay. Mr. Taylor, it's my understanding that in case 22 CR 000712C, you wish to plead guilty to criminal trespass and obstruction of a law enforcement officer. Is that correct?
Yes.
Are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by counsel. Are you satisfied with her representation?
Yes.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes.
Has anyone forced or coerced you to plead guilty?
No.
Okay, I'll accept the plea as negotiated. Good luck to you, Mr. Taylor. Miss Strong or Miss Grace, are you with me?
Yes, Judge.
I noticed a number of indications on the calendar that conflict attorney have been requested. Do we have conflict attorney for those cases?
No, Judge. I spoke with Miss McLeod. She had to leave for a funeral this morning. She'll be back. She said if you can hold her cases out to next week, that will be fine.
Not sure if it's going to be fine with her clients, but
yeah, she
and
had
so-
a
so we
funeral
don't-
she had
so-
to go to in Boston, I think she said.
okay, so
But she
all
put
the
leave in on some of the cases. I looked them up, but I'm not sure about the other cases that's on the calendars that's requesting a conflict.
okay, but we don't have a conflict attorney for any of these people this morning. Is that right?
No, sir.
Okay, so in that case, all the ones that, let's see if, I'd rather not push them all. If it's one of Ms. McLeod's cases, let's push it off for a week. If it's just needing a conflict, let's see if we can, and I'll be on that calendar on Thursday. I know that these calendars are getting big, but I'd rather try to deal with people and get them out of jail if possible. So the ones that need conflicts, let's see if we can get them by Thursday. Is that okay with everyone? Okay, who do we have next?
We can go to position 39 through 40, Mr. Nixon.
And negotiated, please.
Yes, Your Honor.
Come on.
Good morning, Mr. Nixon. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right. Thank you, sir. You can place your hand down. Ms. Falk?
Yes, Your Honor. The state's recommendation on position 39 is time served 48 days, served 24 days from March 22nd, 2022 to March 25th, 2022 and July 3rd of 2024 into today. On position 40, the state is entering a null pros. We do ask the defense to stipulate to the basis and identification for the purposes of this plea.
We stipulate, Your Honor.
Mr. Todd?
Sorry?
Anything further?
No, nothing further. Sorry, the sound is
Okay.
choppy.
Oh, no, you're fine. I just want to make sure. Mr. Nixon, it's my understanding that in case 22 CR 001692F, you wish to plead guilty to criminal trespass and fare evasion. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with her representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, no, sir.
Okay, I'll accept the plea as negotiated, Mr. Nixon. Good luck to you, sir. Okay, who do we have next?
We have on jail court iPhone, we have, I'm sorry. I'm sorry, Corbin, go ahead.
No, go ahead. We're listening to you.
Okay, we have position number 35, Mr. Demetrius Jones.
So for Mr. Jones, unfortunately, we do not have an attorney present to represent you today. We're gonna try to get a conflict attorney. I'm gonna reset your case until Thursday, and I'll see you back on Thursday, and hopefully we'll have someone come down there to talk with you before then, okay?
All right, thank you, sir.
You're welcome. We'll see you back on Thursday.
Your Honor, we have, two conflict cases, which is Norman Gibson and Marietta Annex. If you could give them that announcement so they can be dismissed.
Okay, so who do we have at the Marietta Annex?
That'll be Mr. Freeland.
Mr. Freeman, and he is,
Position number 22.
okay. Good morning, Mr. Freeland. Unfortunately, we do not have a conflict attorney to represent you today. Hopefully, we'll get one before Thursday, and they will speak with you before that time, okay? So I will see you back on Thursday.
Yes, sir.
Okay, I'll see you on Thursday, sir. And who do we have on the Norman Gibson?
That should be position number 51, Tyler Thomas.
And the same announcement for you, Mr. Thomas. We do not have a conflict attorney today, but we will try to get one by Thursday, and I will see you back on Thursday. Hopefully, we'll have an attorney representing you by that time, okay?
Yes, sir. Thank you, Judge. What are these charges in regards to?
Let me see, Mr. Thomas, position 51, you have been charged with. You have been charged in case 24 CR 004811B with battery, which allegedly occurred on June 20th of this year.
Okay, thank you, Your Honor.
Okay, I'll see you back on Thursday, sir.
Thank you, Your Honor.
You're welcome. Okay, who do we have on the jail court's iPhone, I guess?
That is supposed to be bullshit.
We have position number 30, I think it's 32, Mr. Washington.
Is it Michael Washington?
Yes.
Okay, position 52, Mr. Washington. Unfortunately, you're in the same position. We do not have a conflict attorney to represent you today. Hopefully, we'll have one by Thursday. I'm going to reset your case until Thursday, and I will see you back on Thursday, okay?
All right, thank you.
Hey,
All right.
And Your Honor, this is also going to apply to Antoine Watley. I think we may have, I'm not sure if we addressed him yet or not.
He has not been put up on the iPhone yet.
Okay, just to let the court and everyone know, the state is attempting to transfer this entire case back to the DA's office. This is actually a multi-co-defendant case. So it will not just require one conflict attorney, it will require multiple conflict attorneys.
Okay, so let's reset Mr. Watley out at least a week. So will that give you more time to get that done, Ms. Falk?
Your Honor, I'm resending the transfer recommendation now. Due to summer conference, we only have one attorney reviewing these upstairs, so hopefully I can get a response today.
Okay. Just so if not, let's reset it until 7:30.
Okay.
And if it's transferred before then, we'll take it off.
And Your Honor, I don't know if you're willing to grant that on all of these cases, Tyler Thomas, Demetrius Jones, Michael Washington as well, since they're all co-defendants in the same case.
Oh,
and we get all of them transferred at once.
Oh, okay. I didn't realize that So tell me again, I'm sorry, Ms.
So
Falk.
there's a total of, I want to say, 4 or 5 defendants in this. Tyler Thomas.
Okay, and you just give me the, if you
Oh,
have. the-
okay.
the,
Position 54,
Okay.
Antoine Watley.
54,
Position, yes. Position 52, Michael
Okay.
Washington. Position 51, Tyler Thomas. Position, let's see. Just scroll up a little. There was one more. Let me see if I can locate it quickly. That may be, actually, that may be everyone. See. Oh, and Demetrius Jones. Excuse me. So there is one more, and that is position. Let's see.
35.
That's going to be position 35. Thank you.
Okay, so 54, 52, 51, and 35 will be reset 1 week out until 7:30. Okay, and did you get that, Miss Grace? Or Miss Strong?
I have it, but I just want to confirm. So are we these are to transfer or for conflict? Because I know we said that first. I just want to confirm to make sure that we have conflict if need be, but I know you're trying to transfer.
That is, so both are correct. I am trying to transfer these back to the DA's office. But we would need multiple conflict attorneys if the DA's office does not accept this case for a transfer. I will let the court and Ms. Strong know as soon as I know what the result is.
Okay, thank you.
Thank you.
Okay, who do we have next?
We can go to position number 42, Mr. Cornell Pierce.
And this is a negotiated plea,
Yes, Your Honor.
What number?
42. Good
And-
morning.
Oh, sorry, just to ask, is there some garbling on the audio, or is it just that's what I'm hearing? Because I'm getting kind of, some of this is garbled.
I'm not getting any, is
Okay.
anybody else getting any garbling? I'm not.
Understood.
Okay. Position 42, Mr. Cornell Pierce. Good morning, Mr. Pierce. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, good morning, Judge. Yes, sir.
Yes, good morning, sir. Can you raise your right hand for me?
Sir.
Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can place your hand down. Thank you. Yes, Ms. Falk.
Your Honor, the state's recommendation is 12 months to serve 34 days, credit for time served 17 days from July 6, 2024 to today, balance suspended, stay away from the Amico located at 1270 Cleveland Avenue in East Point. The state would ask the defense to stipulate to venue, factual basis, and identification for the purposes of the plea.
We stipulate, Your Honor.
And Mr. Pierce, it's my understanding that in case 24 CR 004453J, you wish to plead guilty to criminal trespass. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with her representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated. Good luck to you, Mr. Pierce.
All right. Judge, does that mean, time served and,
Yes, sir. Yes, sir. And you know you can't go back to that Amico, though.
Okay, is that signature bond today?
No, if you don't have anything holding you, then you'll be released as soon as the jail can process you out, okay?
Well, I was. Okay, I was let out on pretrial on that first case, criminal, property damage.
Okay, you can talk to Mr. Ty about anything further, okay? She'll speak with you.
Yes.
All right.
We can go to position number 53, Mr. Watson.
And have you spoken with him, Mrs. Ty?
Yes, Your Honor.
And what are we doing today?
Your Honor, I want, he has a hold in DeKalb County and he wants to get out. He's been here, for 16 days. But, he is an East Point bindover, so I did want to make a bond argument and, he came over from East Point with a $1,000 bond. And, so I just wanted to make a bond argument, and if not, then I'll need to talk to him about whether or not he wants to plead guilty.
Okay. Let's see, what is his history, Ms. Washington?
I'm sorry, Your Honor, I didn't get this defendant's position number.
53, Mr. Ronald Watson.
Bear with me one moment. Your Honor, this defendant appears to have 42 arrest cycles in Georgia and 1 arrest cycle in Kentucky and 1 arrest cycle in Tennessee. And there appears to be a 2014 criminal trespass out of Fulton County misdemeanor conviction, a 2018 theft by shoplifting out of Fulton County misdemeanor conviction, a 2018 FTA, a 2021 theft by shoplifting with Chamblee Municipal Court, an arrest in 2022 for theft by receiving stolen property out of East Point, another arrest in 2022 for theft by taking out of College Park, a 2023 FTA with Chamblee Police Department, a 2024 misdemeanor conviction for for criminal trespass out of Clayton County, a 2024 arrest with DeKalb County for theft by shoplifting, and that was in April of this year. And that appeared to be the last arrest before the East Point matter for theft by shoplifting. And there does appear to be some prior felony convictions listed. Nothing further.
Given his history, I believe that whoever gave him the $1,000 bond, that's I would not modify that bond.
Okay, Your Honor. He would, and I guess I'm gonna ask for a non-negotiated plea, and that would be, it's a time served sentence, but if I can tell you a little bit about him, Your Honor, he's 49 years old. He does have 1 minor child, a 13-year-old and 2 grown children. He has lived in Georgia all his life. He's a graduate of Benjamin E. Mays High School. He does work through People Ready, a staffing company, and he usually works as a chef at Chop House in Truist Park. He has struggled with homelessness for many years, but he now has permanent supportive housing through Hope Atlanta, where he receives ongoing support. This is an organization that helps people who have experienced homelessness to find housing and get any support and treatment that they need. He was arrested on July 7th. He's been in custody for 16 days. Of course, he didn't see a judge here in Fulton County. It was a bind over while he was at East Point. Well, I won't go into that if he can't get a signature bond. But Your Honor, he's willing to plead guilty today because he doesn't want to lose his housing. He has to be transferred to DeKalb County where he has a hold. And due to his ability, I would ask that he not be required to do the anti-theft course. And I mean, he works through the staffing company to be able to make ends meet somewhat. And so I don't think he's in a position to do community service. So I'd like to ask the probation fees to be waived and no anti-theft and community service. And stay away from CVS is fine.
So the only thing that you're requesting that he do is stay away from CVS.
Yes, it is a theft by shoplifting, cleaning products.
Ms. Falk? I'm sorry.
Yes, Your Honor. No, this happened July 7th, 2024. The defendant did steal fabric softener, detergent, Lysol spray, with the value of $132.79 from CVS. This is not an issue of him stealing food or baby supplies. It's cleaning products. So the state's recommendation is based on the fact that this defendant has 3 prior convictions for theft by shoplifting in the last 10 years. The only reason the state didn't ask for this as a transfer to a felony is because one of them was out of municipal court and we believed we would have an issue showing that he was represented by counsel at that time. So for that reason, we did not send it up as a felony, but 3 shopliftings in the last 10 years. The $500 fine is mandatory. We are asking for the anti-theft course, which given he has 3 theft by shopliftings in the last 10 years, we would believe is warranted. And we are also asking for 40 hours of community service. Again, by all rights, this should be a felony. So that's why the state is asking for all of the conditions we are requesting.
And there's not, on my recommendation from the state, there's not a $500 fine listed.
And Your Honor, that is statutory. Since this is a non-negotiated plea, the state is asking for the $500 fine as per the statute.
And Your Honor, it's not required by the statute that he pays a $500 fine, and you could very well replace that with the 40 hours of community service if you find that he does need to do community service.
And Your Honor, my response to that is the statute does say shall pay a $500 fine. So the statute does in fact require it. If the court chooses to change that, that is absolutely the discretion of the court, but the statute is very clear.
And the statute is also clear, stating that the judge must take into consideration his indigency and, when it comes to fines and fees.
And the defense just stated he is working currently, so I'm not sure what the argument is as to indigency.
There's a lot of people that are working and are still at the poverty level.
Right, but there is a showing in that case of indigency, and I don't believe the defense has shown that.
Well, his address that's listed shows that he is in supportive housing with Hope Atlanta, so that is that's the proof.
We're
That's-
representing him as also proof, because you have to be indigent for our services.
Hey, are y'all done? All right, so I'm mostly concerned about the number of theft by shopliftings, and maybe that's because he's indigent, but how do I go about best deterring him from, and I think that's what he's being returned to DeKalb County for, is to deal with the theft by shoplifting there that occurred a couple of months prior to this one.
And Your Honor, in this housing that he has now, it's not only housing, it's permanent supportive housing where he receives ongoing support for, community, ongoing support for any issues that he may have. And I believe that they can also help him with, if he goes back there and requests support for, they'll know that he's been gone for a month. He already has to go to DeKalb. He doesn't want to lose this housing. So
okay, I understand, but let me just say this. Let me just say this to Mr. Watson. Once you plead guilty to this theft by taking, and you By pleading guilty, you're accepting responsibility of it. If there is another theft by shoplifting, it's gonna be a felony. Okay, so, you know, even if I take the recommendation of Ms. Atai, that will be, it's because of her arguments that I have decided that I'm going to accept the recommendation. This is going to be a time served plea, and I'm going to let you go to DeKalb County and deal with those issues. But if there is another theft by shoplifting, just know that the next judge is probably not gonna do that. You understand me? Okay. So, Mr. Watson, it's my understanding that in case 24 CR 004703F, you wish to plead guilty to theft by shoplifting. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol at the present time?
No, Your Honor.
You've been represented by counsel. Are you satisfied with her representation?
Yes, Your Honor.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, Your Honor.
Has anyone forced or coerced you to plead guilty?
No, Your Honor.
The court sentence is 12 months to serve 32 days, credit for time served 16 days, balance suspended, stay away from the CVS at 2907 Main Street in East Point. All right, you're getting a time served sentence from this court. I implore you, get back on the right track and, you know, and do the right thing, Mr. Watson.
Thank you, sir.
All right, good luck to you, sir.
Thank you, Your Honor.
All right, thank you.
Who do we have next?
Jail court, folks, we have position number 54, Mr. Watley.
Mr. Watley, good morning. Unfortunately, we do not have a conflict attorney to represent you today. I have requested that we get someone to represent you by Thursday. So someone should be getting in touch with you by Thursday, and I will see you back personally on Thursday, okay? But you should have someone speak with you about your case before then, sir.
All right, thank you.
All right, you're welcome.
Judge Moore, I'm sorry, I thought Watley was for next Tuesday.
Oh, is Watley one of the 54? Oh, yeah, I'm sorry. It will be it'll be next Tuesday. Mr. Watley. Okay, but you should still have someone come speak with you, sir.
All right.
Who do we have next?
We can go to position number 55.
This is going to be this is Mr. Annis. Pronounce the last name for me.
Witherspoon?
No, Witherspoon, I'm sorry. Mr. Witherspoon, is this going to be a waiver and a modification?
Yes, Your Honor.
Okay, do you want me to arraign him or are you gonna file a waiver?
I'll file a waiver.
Okay. What's the current bond?
It is $2,500, and he is also a Union City bind over.
May I get his history, please?
Yes, Your Honor, 3 prior arrest cycles, a 2022 arrest for simple battery in DeKalb, no disposition was listed. A 2022 misdemeanor conviction in Clayton County for battery family violence. A 2023 arrest for battery family violence with Morrow Police Department, no disposition was listed, nothing further.
Ms. Falk?
Yes, Your Honor. This incident happened back on June 9th of 2024. Officers arrived and spoke with Miss Destiny Starnes, who was standing beside her vehicle, and flagged down the officer. She stated her boyfriend, the defendant, got into an argument with her, wanted to know where she had been, grabbed her by the arms and began shaking her and told her not to ask him any questions. She stated that he began to get rough with her and she pushed him off of her. She said she was trying to remove his things from her vehicle. He slapped her and knocked her glasses off And then she said that the defendant, she told the defendant she was going to call the police, and he ran into the wood line. Officer Taylor observed scratches on her left arm, and she also stated that her chest was in pain and her left eye was in pain. At that point, Grady EMS arrived and did evaluate her, but she advised she did not wish to go to the hospital. As you have heard, Your Honor, this defendant has a prior family violence battery conviction out of Clayton County. That was 2022 CR 03159. The disposition was on August 18th of 2022. That in that case, the mother of the defendant was the victim. We also are showing, as I stated, that the defendant has, as pretrial has stated, the defendant has, I believe, 4 arrests, all for various family violence charges. There is the September 2023 arrest out of Morrow Police Department for family violence battery, that Clayton County conviction for family violence battery, and a 2022 DeKalb County case for simple battery and criminal trespass. For that reason, the state is asking that the bond of $2,500 remain as set. We are also requesting in this case that this go to reset jail jury before the judge on this case would be Judge Dixon.
What's the bond broken down, Ms. Falk?
Yes, Your Honor. Let me just take a look at the bind over paperwork. We also would like to sound from Miss Destiny Starnes if she is here today. It looks like the bind over paperwork set the bond at $2,500 total for 1 count of battery. We did add a 2nd count of battery in the alternative. So the original bond was set only as to the 1 count of battery. So we would ask for a $5,000 split bond, $2,500 surety on the battery charge, and $2,500 signature bond through pretrial services on the 2nd battery charge, since under SB 63, he is not entitled to a signature bond through the jail.
Mr. Time?
Yes, Your Honor. My client is 24 years old. He is a Georgia resident. He's a graduate of Langston Hughes High School. I spoke with the complaining witness. I was surprised to find out that with the request, the plea offer being asking for him to serve 12 months, that nobody from the state has reached out to her. She did say that she does not want to press charges. She's not afraid of him. She doesn't want contact because the relationship isn't working out. They were living in her car or in a tent in the woods, and she stated that she couldn't join the call today because she's starting a new job and would be at work at this time. But I was just surprised that nobody called her. Sorry, Your Honor. He was arrested over a month ago on June 21st, and he came over as a bind over on July 17th, 26 days later. And it looks like at that time he turned himself in. When I look at the Union City paperwork, it states that they were dispatched to East Point Jail. So it looks like when he found out about the warrant, he turned himself in, only to sit there, with this $2,500 bond for 26 days before he was bound over here. Due to the length of time that he's been in custody and the fact that the complaining witness is stated, she's not afraid of him. She's not afraid for her safety. He has 1 prior misdemeanor conviction. And he doesn't have 4 previous arrests. He only has 3 previous arrests. So I am asking for a $2,500 signature bond through pretrial services, even if it's at level 3. He's been sitting for over a month with a $2,500 bond that he can't pay.
Your Honor, just a couple of points of clarification. We did in fact reach out to Miss Destiny Starnes and attempted to contact her. I'm sure Your Honor is unsurprised that she did not return our phone calls, which is not uncommon in domestic violence cases. Secondly, it's not showing, or at least we're not showing through the police report that he turned himself in. He was actually at East Point Jail and had and was in reference, the officers from Union City were dispatched to East Point Jail in reference to him being wanted out of Union City, at which point he was then taken into custody by Union City and brought over to the jail. So that is what we're showing based on the reports, is the circumstances of how he went from one place to the other.
What was he at East Point Jail for?
Let me see. It's not stating what he was arrested at East Point Jail for, just that they were dispatched out to him being a wanted person.
But it doesn't state that he was arrested and that's why he was at East Point Jail. And I don't see that. And he's been arrested 3 times and that wasn't in 2024. So he was at.
I'm merely stating the police report does not indicate he turned himself in and was just waiting at East Point Jail for something.
History doesn't show that he has an arrest in 2024. So if he was at East Point Jail, he was turning himself in. Maybe not to the right jail. How do people know where to turn themselves into? Only to sit for a month, more than a month. So that's the clarification that's necessary here.
Okay, it'll be a $500 good bond on each charge, makes for a total of $1,000 good bond. No further contact with Destiny Storms. No drugs, alcohol, weapons while out on bond. Good luck to you, Mr. Witherspoon.
Next, Your Honor, we can go to position number 12, Mr. Roderick Brown. 12, position 12, Roderick Brown.
Vigiletti, a non-negotiated plea.
Your Honor, actually, I hate to do it a bit, but I'm wondering if it's possible to reset this case either for Thursday or this coming Tuesday. Mr. Brown works with PAD and they are prepared to pick him up and take him right to a treatment program. But he very wisely today informed me that he is on felony probation and I need to connect with his felony probation officer because I don't want to set all of this up and then find out he has a warrant for that or he's in violation of that. So I want to get on the same page with her before we get him into treatment, Your Honor.
Let's reset him until next Tuesday, 7:30. Okay?
Thank you, Judge.
All right, we'll see you back next week, Mr. Brown.
Thank you, Your Honor.
I see you. Third row. Come on, Roderick.
And Your Honor, while we're transitioning, if we could, please make an announcement on Jericho Ashley. I initially did request a reset to a competency calendar, but Your Honor, I'd like to give it one more try to get Mr. Ashley on his necessary MH medication because I know that would help this situation. The offer from the state is not requesting more jail time, so I just hate to put him on a competency track if I don't have to, Judge.
So what are you requesting, Ms.
Is it
Vigiletti?
possible to reset him to SAP one more time so I can try to get him on some medication?
Okay, so can we reset him for 7:30? Or
That would be great, thank you.
okay, so positions 5 and 6, Mr. Ashley reset for SAP 7:30. Okay,
Thank you, Judge.
you're welcome.
We can go to position 13 and 14, Mr. Carter. He just needs a conflict announcement.
Okay. Yes, good morning, Mr. Carter. Unfortunately, your attorney, Ms. McLeod, is on leave. Your case is being reset until 7:30. Okay, so I'll see you back next Tuesday.
Okay.
All right, see you next Tuesday, sir.
And we can go to position number 23, Jeffrey Hopper.
I'm sorry, tell me again who this is?
Position 23.
23?
Position 23, Mr. Harper, he's being transferred to the DA.
Okay, so your case has been transferred to the DA's office, Mr. Harper. You'll get notice of your next hearing date, sir.
Thank you,
Okay.
Your Honor, I know you.
Yes.
You reset a couple of the conflict cases. I don't know if they belong to Ms. McLeod, but I spoke to Ms. McLeod yesterday and she said she won't be available until August 11th.
Oh, okay. So,
I know you reset some to July.
right.
I don't think she's gonna be available then.
I know she has a trip planned sometime.
Right, yeah.
Yes, she said she's going to several places, actually.
So,
Excuse me, Judge,
Miss-
I spoke with
yes.
Mr. Jordan and he said she will be back on Wednesday for the Thursday's calendar.
Okay,
So the ones that's noted on the calendar for her, we can reset those for Thursday, but I'm not sure about all these others. But she is going on her trip.
so let's reset as many of them as we can for when she is it next Thursday that she's going to be back?
No, if I'm not mistaken, I think Mr. Jordan said this Thursday. Let me
This
check him again.
day after tomorrow? I mean, this Thursday.
Mr. Jordan said she'll be on Thursday's calendar.
Okay, so let's place all of Ms. McLeod's cases on
Thank you.
Thursday's calendar. I apologize in advance. That's probably going to be a large calendar. Okay, are we able to take anyone else right now?
Yes, we can go to position number 11, Mr. Christopher Branch.
No.
Okay, and so are you going to file a waiver for Mr. Branch?
Yes, Judge.
And this is a bond modification request.
Yes, Your Honor.
What is the current bond?
His bond is a $2,000 surety bond.
It's a bench warrant, Your Honor, from a failure to appear.
Okay, and where did he fail to appear?
Judge Richardson's plea and arraignment calendar on April 26th of 2022. And he notably also FTA'd a previous plea and arraignment calendar in 2021. However, he updated his address with the court after his first FTA, so this is really his second FTA.
Ms. Vigilante, is there any reason that I shouldn't follow my normal practice of returning it to the division judge who issued the bond for modification?
Your Honor, my concern today is just the cost to Mr. Branch of waiting to have the bond argument because he doesn't work in the same place that he has residence. He's a maintenance supervisor. And so, you know, he really does need to get back to work. And that's why I wanted to bring this argument to you today.
If you can petition Judge Richardson, maybe to get him on a calendar as quickly as possible.
Okay, Your Honor.
All right, good luck to you, Mr. Branch.
Thank you.
Next, we can go.
Who do we have next?
15 and 16, Mr. Carter. Then Liano.
This is going to be a negotiated plea and a null pros.
Yes, Your Honor.
Good morning, Mr. Carter. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me, please? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth? Okay, you can place your hand down. Thank you. Ms. Desiano?
Your Honor, state's recommendation is time served, 38 days, credit for time served, 19 days. That's from October 3rd to October 5th of 2023, and then July 8th, 2024 to today. And then position 16 will be Nawprost. I'd ask the defense to stipulate to venue, factual basis, and ID for purposes of the plea. Nothing further.
We do stipulate, Your Honor. I did just want to say on the record, Mr. Carter was in custody when he failed to appear. I'm still waiting on formal proof from Smyrna Jail, where he was in custody on a Sandy Springs charge, but I just wanted to state it on the record. I know it's going to be Nawprost.
Okay. Mr. Carter, it's my understanding that in case 23 CR 005913E, you wish to plead guilty to giving false information to law enforcement. Is that correct?
Yes.
Are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by counsel. Are you satisfied with her representation?
Yes.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury? Has anyone forced or coerced you to plead guilty?
No.
I'll accept the plea as negotiated. Good luck to you, Mr. Carter.
Thank you, Judge.
And have we tried to accommodate whoever needs the Spanish interpreter? I know Ms. Chancey's been on the line for a while.
You have the interpreter online?
Yes,
Okay.
she's been with us. Good morning, Ms. Chancey. Appreciate your patience this morning.
Oh,
Thank
you're
you.
very welcome.
This is position number 19.
Okay, and what are we doing with him this morning, Ms. Bucciolati?
Your Honor, I did speak with Mr. Dos Santos Franco a bit yesterday, but I do need to speak with him again with the translator present to ensure we're on the same page. I'm not
Okay.
sure how the officers want to do that. I have my cell phone. I could do a breakout room with the interpreter, but I need an officer to tell me how they want that to be done.
We can do a breakout room in here. It's just, I can put them in the back. It's just.
Well, it would just cause out of court.
Oh, okay.
Well, I mean, if you need us to pause, I'm happy to pause for a little while you speak with him.
I would just have to ask, who is that on jail court's iPhone? Because if it's one of the attorneys in here that's not Ms. Vigilante, you guys can go ahead and do him and we could take her out with the guy.
Who's on jail court's iPhone?
We have position number 17 and 18, Mr. Joshua Delmar.
Mr. Delmar, your case is going to require a conflict attorney to represent you. Unfortunately, we don't have one today. As such, your case is going to be reset until Thursday, and hopefully we can get somebody down to speak with you before that time.
Hey, I just need you to put an address on my file.
Okay, as soon as we get an attorney for you, we'll get your address updated, okay?
Thursday?
Yes, I'll see you back on Thursday.
Yes, sir.
Okay. So courtroom 2, how would you like to handle the
We can go into a breakout.
Okay, so court will be in recess while courtroom 2 and Ms. Chancey go into a breakout.
Okay,
Unless wait, one second. Who's on jail court's iPhone now?
We have positions number 27 and 28, Mr. James Brooks.
Okay. Do you all want to go ahead and do this negotiated plea real quick?
Yeah, we can take Ms. Vigilante out.
Okay, all right.
I'm sorry, Your Honor, this is positions 8 and 10.
Okay, well, unfortunately, this is Miss Vigiletti's case, so she's. If you can get position 27 and 28, we can do that case, but we can't do Mr. Bentley until Miss Vigiletti comes back.
You need
Excuse me.
27, 20 I do have 27 and 28.
You need something, Miss Grace?
Yes, is Miss Vigiletti going into a breakout room or not? Are we?
Yes, but not with quorum, so she's gonna log on a different device.
So Vigiletti and who is going in the breakout room?
Spanish.
Miss Chansey, the interpreter.
Okay, thank you.
Okay.
And this is position 27 and 28 here.
Okay, very good, Mr. James Brooks, and this is going to be a negotiated plea, is that right, Mr. White?
That's correct, Judge.
Good morning, Mr. James Brooks. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video? Okay. Can you hear me, sir?
Yes, sir.
Okay. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you, sir. Ms. Desiano?
Your Honor, state's recommendation is 12 months probation, serve 46 days, credit for time served 23 days. That's from June 14th to June 15th of 2022, and then July 3rd of this year to today. Balance probated, no further contact with Amber Gary. Stay away from 2873 Pearl Street in East Point. Family Violence Intervention Program, 40 hours of community service, and no firearms while on probation. Position 28 will be null pros, and at this time it asks the defense to stipulate to venue, factual basis, and ID for purposes of the plea.
Still stipulated. It's standard.
Anything further, Mr. White?
Judge, we just asked you waive his probation fees. He is not in the strongest financial position, so we're asking you to waive his waive his probation fees and allow him to go non-reporting as soon as he completes all of his requirements.
Okay, I'm not able to let him to waive the probation fees at this time, but I will allow it to go to a non-reporting status once he completes the terms. As such, he won't have to pay the fees after that. So, Mr. James Brooks, it's my understanding that in case 22 CR 003808J, you wish to plead guilty to battery family violence. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol at the present time?
Yes, sir.
Okay. So my next question was, are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
Yes, sir.
I'll accept the plea as negotiated, Mr. James Brooks. When you complete the terms, it'll go to a non-reporting status. So the sooner you get it done, the sooner you won't be on reporting probation, okay?
Yes, sir.
All right, good luck to you, sir.
Thank you, Your Honor.
Your Honor, I was having some tech issues. May I inquire who I'm sending orders to today? Is it Ms. Strong?
Yes.
Okay, thank you.
Jay's gonna be here. Or he's already been. He's like, come Oh. Just low functioning probably.
And jail courts, this is Mr. Bentley.
Yes, this is Mr. Bentley, yeah.
Okay, Mr. White. I understand that this is Ms. Vigiletti's case, but she has noted that it's going to be a not guilty and a waiver of appearance on the announcement sheet. Would you have any problems with me just letting him know that so that they don't have to stay there with him? Or would you?
So long as she wasn't planning on making a bond argument, of course, I have no problem with that.
Okay, there's not a bond request on the
Okay.
listed on the announcements this morning. Mr. Bentley, your case, good morning, sir. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Your case is going to be returned to the division judge and you'll get notification of your next hearing date, okay?
Okay.
All right, good luck to you, sir. Thank you, Mr. White.
No worries, Judge.
Court will be in recess until someone else is ready to proceed.
Carter. Worldwide. We're calling.
No, you got, I'm gonna figure out that.
Your way. All right, so good. Nice job.
On the right side. To the left, on the right. To the left, on the right.
What makes me feel.
How you doing, brother?
I'm not missing for a good day. You know, our people. You're welcome.
See you.
All right, good here. Handsome man.
Just piss off. So is the cafeteria that shut down, send it to the same place?
Well, same place, it's like if you're leaving.
Right.
If you go down this hallway, sorry, I'm not, we go down this.
So this is Thursday.
No,
that's what I mean, the other. Oh, that's why, because when I knocked these, I heard someone tell, I'm like, really?
Yeah, I know. It broke like.
Shot, broken shit out here at the jail.
Okay, Gopi, what floor you on?
Blunt, I only got two more. I'm on 4 North.
Who do we have?
I have, what's the name? I have position number 7, Mr. Beck.
We'll have to wait till Miss Vigilante gets back. She's still in a breakout room.
All right, what about 43, Seabrooks? Is that Vigilante?
No, that's Miss Atai. Seabrooks?
Yes.
Yes, we can do Seabrooks.
Don't Seabrooks to come in. Seabrooks, come on.
And this is going to be a waiver and a bond modification request.
Yes, Your Honor.
What's the present bond?
It is 2,500.
And what's the history, Ms. Washington?
Yes, Your Honor. 16 arrest cycles with multi-state interaction in Georgia and in North Carolina. There was a 2015 FTA. Also, a 2023 simple battery misdemeanor conviction out of Clayton County. In 2023, the defendant pled nolo to giving a false name in Snellville. In 2023, there was a misdemeanor conviction out of Clayton County for battery family violence. In 2024, the defendant pled nolo to disorderly conduct in Clayton County. And the last arrest was February 15th of this year with Snellville Police Department for a probation violation regarding the giving false name incident. Also, there appears to be a hold with Roswell Police Department for a failure to appear, and that warrant date is June 4th of 2024. Nothing further.
Thank you, Ms. Falk.
Yes, Your Honor. This is the case, Your Honor, addressed on July 2nd of 2024. And Your Honor gave a $2,500 good bond, 1,000 on count 1, 500 on counts 2, 3, and 4 for a $2,500 surety bond. You also ordered no further contact with minors ZH and SS, stay away from MARTA property, and a social worker visit. I'm not sure if Your Honor remembers this case, but it is the case where the defendant exposed himself to 2 young juvenile girls at the MARTA station and then proceeded to follow them out of the MARTA station. Police then intervened when the girls told them he was following them outside of the station. They did attempt to arrest him. He twisted, contorted his body to prevent from being handcuffed and kicked at the officers to prevent from being handcuffed, which is what led to the 3 counts of willful obstruction. The state doesn't see any reason based on the history. And we do ask that the bond remain as set.
Okay, and just so you know, Ms. Falk, you were going out quite a bit, so I think I got the gist of what you were saying, but we might not have gotten all of it. But I did get the gist of what you were saying.
Okay. Thank you.
Ms. Atai, was there a social worker visit?
Your Honor, I think was he on the SAP calendar earlier and was reset from last week? I think that he was. Our social worker is speaking with him right now. There is no change there. and really, there is no change, but he has been in custody for 22 days. He does firmly deny the allegations as stated in the warrant. And I believe that this was reset from SAP because there was no contact made with the complaining witness, and I don't have any information for that either, even a phone number or anything. I don't see that in the, of course, that needs to come out in discovery, but he has been in custody for 22 days. I spoke with his mother. He's lived in Georgia all his life. I think he is recommended for a pretrial bond at level 3. And I would just like to ask, at least if the willful obstruction, the $1,500 bond on those can be converted to a signature bond through pretrial services.
Okay, I think that normally when I request a social worker visit, I'm concerned about housing and where the individual will go once they are out of custody. Do you know whether or not he is residentially challenged? Does he have a place to go?
He is residentially challenged, Your Honor, but I spoke with his mother and he could live with her. And she gave me an address. She's lived in Georgia for her entire life, and was living with her. But yes, he has been homeless for the last 5 years. But his mother lives here in Georgia.
And she is willing to take him in?
Yes, Your Honor. I think she said she's going to join the call.
What's the mother's name?
Patricia Seabrooks.
Is Ms. Seabrooks with us? So, Mr. Ty, if you will have Ms. Seabrooks join us, whether you can get her on the line today or whether I have to reset this until Thursday, I'd like to hear from her just so the court knows that she's willing to take him in, and that anything else that she may need to tell me about the situation. So I'm willing to reconsider this on Thursday if you'd like me to.
I will be here on Thursday, but if you just give me a minute, or while other cases are going on, I can call her.
Okay, that'll be fine. Are we ready with your other case though? The interpreter case here?
Yes, Your Honor.
Excuse me, Judge Myra, will there be Miss Watson Cafe on for Mr. Allen, position 1 through 4?
No, that case is being returned to the division judge. He'll get notification of his next hearing date.
All right, thank you.
Okay, thank you. And so this is position number 19. What are we doing with Mr. Franco today?
Your Honor, Mr. DeSantos Franco would like to enter a plea of not guilty.
El señor Franco quisiera entrar una declaración de inocente.
I'm sorry, are you gonna file a waiver?
I'm happy to file a waiver, yes.
Voy a presentar entonces la renuncia de...
Okay, anything further?
¿Algo más?
I don't believe so, Your Honor. I have spoken to his family and they are working on helping find him a place to live. So that's the reason I'm not requesting a bond modification this morning.
Okay.
No sé su señoría, pero he hablado con la familia quienes le están tratando de encontrar un lugar para vivir.
Are you requesting that it be returned to the division judge or placed on some other calendar?
Yes,
Yo
Your
le
Honor.
pido que él que haga una modificación de la fianza. ¿Está usted pidiendo que regrese al mismo juez o a otra división?
I'm requesting it be returned to the division judge, Your Honor.
Sí, yo pido que se regrese al juez original, su señoría.
Okay, if nothing further, good luck to you, sir.
Y si no hay nada más, buena suerte, señor. Your Honor, could I please have his case number?
Yes, it's case number 24 CR 004808J.
Thank you, sir.
Okay, anything further of Madam Interpreter this morning?
I don't think, Your Honor, but if you want me to make an announcement.
I don't think we have anyone else in the courtroom, so thank you.
Okay,
Ms.
you're
Chancy.
welcome.
I
Thank you.
appreciate it. Have a
You're
good
welcome.
day.
Have a good day. Bye-bye.
Thank you. Let's see, while you were gone, Ms. Vigiletti, positions number 8, 9, and 10. I noted that it was a not guilty waiver of appearance on the calendar that was announced. Mr. White sat in for you. I hope that was okay. And I addressed him and let him know that his case was being returned to the division judge.
Okay, thank you, Judge.
Okay.
And Your Honor, if we're waiting on additional clients, I will note that I believe our DVBW case is here. She runs a nonprofit called Time to Thrive, and I see Time to Thrive is on.
Okay, and you're representing her?
Yes, Your Honor.
Okay. Who do you have on the jail court side phone?
This is Mr. Beck again. Position number 7.
And that's also my
Okay, and this is not guilty waiver of appearance and a bond request?
Yes, Your Honor, I did want to request that his previous bond be instated today, but after speaking with his mother, who he was released to last time, it sounds like once again, we need to find him someplace to live. And because he does have an open felony case, we have some time to do that. And so I'm just requesting this return to the division judge, and we're going to get to work on finding Mr. Beck someplace to live.
Okay, yes, good morning, Mr. Beck. Your case will be returned to the division judge. You'll get notification of your next hearing date. All right. And I think that on the main calendar, we still have position 36 to deal with.
Your Honor, position number 39, Mr. McDermott, he was released.
What? Brian McDermott?
McDermott was released?
Yes.
Okay. So that was going to be a negotiated plea, but I guess not. Mr. White?
No, Judge, we filled out paperwork and I'm now hearing that he may have private counsel. He never mentioned any of it to me, so good for him, he's out.
Okay, all right, so we'll make note of that. So we're still waiting on to get
I
that
apologize. Who was the announcement just made on what position did Mr. White?
36. Apparently he's been released.
Okay.
Brian McDermott.
Okay, thank you.
So bondage.
Are we going to have this add-on? I've got an add-on, Aaron Bentley. And I also have a probation revocation, Nicholas Taylor, that we haven't yet to complete. Mr. Ty, do you have an announcement?
No, I thought we were calling Nicholas Taylor, for the probation. I think that
No, I was just saying that we still have Mr. Taylor to do and Mr. Bentley to do on the add-on calendar. And do you want me to give you till Thursday to address your other client here?
Yes, Your Honor.
Okay, tell me his name again, I'm sorry.
Ulysses Seabrooks.
Okay. So, Mr. Seabrooks, we'll see him back on Thursday if you can get in touch with his mother to address the court at that time.
I just spoke with her, Your Honor. she said that he would be living with his father, and so I need his father to join the Zoom call and.
Okay, all right, so we'll reset him for the father then. That's fine with the court.
Thank you.
Okay, so,
Okay.
7:25 for position 43, Mr. Seabrooks. We'll see you back on, Thursday, Mr. Seabrooks.
Hold on. Your Honor, did you want to see, Mr. Bentley again?
Aaron Bentley,
Yes.
what are we doing with Mr. Bentley on the add-on calendar today?
I apologize, Your Honor. I did not notice an add-on calendar. Let me look. If he's an add-on, there must be a reason.
Your Honor, I had him on the
Oh,
regular
oh, I-
calendar. I did notice that he had a case that was missing that I added. I didn't, is it 22 CR 4156F?
What, yes,
Okay,
Okay. So I believe that was addressed in his main, because he pleaded not guilty when I was not here, right, to all 4 cases?
right.
So 3 were on the regular, and then this add-on must be that additional case?
Okay,
okay,
so it's the same announcement, I'm assuming?
Yes, yes, yes. He has 4.
okay,
I'm sorry, I didn't realize there's an additional calendar for that 4th one.
okay. So no, we won't need him again.
Right.
Okay.
Do we have anyone on from probation? I only have one on the probation calendar, Nicholas Taylor.
And Your Honor, I know we did speak to Nicholas Taylor earlier because he was also on the SAP calendar. I'm wondering if maybe he was taken back prematurely. Let me ask the officer.
They took him back to the one.
Oh, okay.
Oh, I have, no, that's Kevin Taylor. Oh, we took a plea on Mr. Taylor.
Yes, Judge, I'm gonna ask them to see if they can bring him back.
Okay.
Your Honor, they're going to get him to bring him back for the probation matter. Sorry about that.
Okay, thank you. So, good morning, Officer Allen. We'll be with you as soon as he comes back. Thank you.
Okay, thank you.
So let's address Miss, on the BV bench warrant calendar, Miss Strong.
Yes, sir.
No, I'm sorry, Miss Aaliyah Strong, who is on the DV bench warrant calendar.
I forgot her last name was Strong. Thank you.
Okay. All right, good morning, Ms. Strong. This is the DV bench warrant calendar that we're conducting by video. Let's see, I take it that Ms. Strong missed the court date?
Yes, Your Honor.
She missed plea and arraignment on July 2nd of 2024 before Judge Roth.
What's the problem, Ms. Vigiletti?
Yes, Judge. I talked to Ms. Strong yesterday. She tells me she checks her mail every single day. She didn't move. She has maintained the same address, and she received the letter notifying her to appear on July 9th. She does live in South Fulton and told me that this has been an ongoing issue in South Fulton of mail being unreasonably delayed for no reason. And so when she went to the court to get this hearing, Your Honor, she did update her address to be her aunt's address because her aunt is responsible and will, make sure she gets the mail, and her aunt lives in a completely different part of town. So she's hoping there's no further address issues. She did reach out to her pretrial officer. Her pretrial officer told her to reach out to the email address on the notice that she received on the 9th. And when she didn't hear back, was kind of getting the runaround, that's when she went to the courthouse. So you can see she received the letter on the 9th, and you can see that she went in person on the 15th to get this taken care of. She has been compliant with the no contact order. So if the complaining witness showed up, that wouldn't have been a way she would know, because she's not having any contact with the alleged victim. She does tell me she's in good standing with pretrial services. Your Honor, she does run a nonprofit. It's called A Time to Thrive Beyond Grief. She has a small contract with the city. They are working with families who lost someone to gun violence, and her son does start school on August 1st. I don't foresee a reason why this would happen again. I think it really was just a mail issue. And like I said, she will be using her aunt's address. I've also instructed her to, if you're not hearing things for a while, to call the clerk's office proactively.
Okay, Ms. Strong, I normally set aside a bench warrant on one occasion, and I'll set it aside for you at this time, but you need to keep in touch with the court and make sure that you attend your next court hearing, okay?
Your Honor,
Oh, sorry.
and
I usually do. It's just when I originally got released, I was just told that I would get something in the mail. So I didn't know that we were going to get a notice as quickly as we did. But again, when I got the notice late, I still, made sure to follow up. So I don't foresee that happening again. And my pretrial officer did tell me he will notify me via email as well, moving forward, so I don't miss any further court dates.
Okay, but don't rely just on the pretrial, okay? Make sure that that you continue to check with the court. Ms. Falk?
Quick question.
Hold on 1 second.
Okay.
No, I'll be right back with you. Yes, Ms. Falk.
Your Honor, since the state does want an opportunity to respond, I would just like to ask just to verify that pretrial has been in constant contact with her. We do show an FTA from 2017 outside of the state in, I believe, Florida. She's a multi-state offender, so I just want to make sure she is actually complying with pretrial services at this point.
Yes, just give me one moment and I can look that information up for you.
Thank you.
Okay.
If you need it too, I do have his phone number and email as well. I don't know if he's on the call or not, but yeah, it's
That's
Gerald
okay.
Brown.
That's okay. Ms. Washington also works for pretrial services.
Oh, okay.
So, Your Honor, I do see that there were a few misinteractions. On the I believe she was supposed to report once a month. And that there were some email exchanges, I believe. There was a missed anger management class, but that was in May. But otherwise, I'm seeing that as far as I can see, there were, compliances, but there was a missed court hearing on the 2nd. And we were able to speak with Ms. Strong, and she was aware of that FTA. So as far as I know, it would be, she's been compliant. But just other than just the general missed call back, I don't see anything other than that.
Has she taken the anger awareness class?
Oh, okay.
Hold on.
I cannot see the notes are not as detailed, and unfortunately I don't have further information, but I do see that one was missed, but it doesn't state whether there was another one that was taken.
Okay, so Ms. Strong, if you have not completed that anger awareness class, you need to go ahead and do that, okay?
Question. I know no one ever told me about an anger management class because I haven't even been to court on this case at all. Like this is my first time.
sometimes as a requirement of the bond, a judge orders that you complete anger awareness. So if that's part of a requirement, Ms. Washington, would you please have the officer get in touch with her and make sure that she understands that she has to take that class? If it's part of it.
That's
Okay.
even like before the case?
Yes, ma'am.
Oh, okay. Okay.
All right. All right. So on this occasion, that'll be set aside. Ms. Vigiletta will prepare that and get it to the court.
And Your Honor, I just verified, Your Honor did order one-day anger awareness as part of Your Honor's order on January 22nd, 2024.
Okay, so apparently I
Okay.
saw you, Ms. Strong, and I ordered that you take that class, so you need to go ahead and take it, okay? And
How do I?
you can get in touch with the officer and they'll advise you.
Okay.
In Your Honor, I do believe that the officer will mention that to you. So he's typically pretty good about getting in contact. So
Okay.
I'm sure he'll reach out to you, but I'll also message him to let him know as well.
So do I have a new court date now?
You'll get notification of your next court date.
Okay.
Okay? All right.
Okay.
All right, you have a good day, Ms. Strong.
Thank you. I appreciate it.
Okay.
Bye.
Let's see, we have Mr. Taylor back with us. Officer Allen.
Sorry, Your Honor.
Okay, no problem. So what's going on with Mr. Taylor?
Your Honor, the defendant was required to report to probation for the charge of obstruction of an officer, where he was required to stay away from the incident location and pay a fine of $440. Your Honor, he has been in custody since July 11th, 2024. Is 173 days remaining on his case. Your Honor, because he's been in custody since July 11th, we do ask for his case to be time served.
Time?
Yes, Your Honor, I would just ask that you accept the recommendation of Ms. Allen and time served.
Okay. I'll accept probation recommendation. Time served, Mr. Taylor. Good luck to you, sir.
Thank you. What was the location again? I don't have to stay away from anywhere for the obstruction.
Oh, the stay away?
Yeah.
Probation.
Yeah, you're done.
Okay.
That's really, but that's not.
I can-
Okay, is that it? Is that it for Mr. Taylor?
Yes.
What does he need, Mr. Ty?
He doesn't need anything.
Okay, all right. Thank you for being here, Officer Allen. See you
All
next
right.
time.
All right.
Okay, I think that completes the calendars, if I'm not mistaken. Ms. Strong, whenever you're ready.
Position number 1 and 2, 3 and 4 are being reset, returned to the division judge. I'm sorry, 1 through 4. Position number 5 and 6 are reset for SAP 730. Position number 7 was waived arraignment, reset jail jury. 8 and 9 waived arraignment, reset jail jury. 10 and 11 waived arraignment, reset jail jury. 12 was reset for SAP 730. 13 reset for Thursday's SAP calendar. 14 reset for Thursday. 15 was a negotiated plea. 16 was null pros. 17 and 18 reset for Thursday. 19 waived arraignment. 20 negotiated plea. Position 21 was an amended bond with a $10,000 signature bond through pretrial level 1. 22 reset for Thursday's SAP. 23 was transferred to Superior Court. 24 and 25 will reset jail jury. 26 reset for Tuesday's SAP calendar. 27 negotiated plea. 28 null pros. 29 negotiated plea. 30, 31, and 32 were null pros. 33 was a negotiated plea. 34 was null pros. 35 was reset for Tuesday's SAP. 36 was released. 37 and 38 reset for Thursday's SAP calendar. 39 was a plea. 40 was null pros. 41 and 42 were a plea. 43 reset for Thursday's SAP. 44 was reset for Tuesday's SAP. 45 and 46 were also reset for Tuesday's SAP. 47 and 48 were released. 49 was a plea. 50 was null pros. 51 reset for Tuesday's SAP. 52 Tuesday's SAP. 53 was a plea. 54 Tuesday's SAP, and 55 was a $1,000 good bond with a no further contact and no drugs, alcohol, or weapons. The add-on was reset jail jury for both cases, and the DV bench warrant was set aside.
Questions, concerns? If not, you all have a good rest of your day. I will see you all on Thursday.
Thank you, Judge.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. And once I get the paperwork, we'll get it signed.